Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson. Let me introduce you to our panelists for today. First, we have Mr. Andre Wong, who is the General Counsel for the North Pacific Union Conference of the Seventh-day Adventist Church. We have Ms. Bettina Krause, who's the editor of Liberty Magazine. We have Mr. Rushern Baker, who's the president and CEO of the Baker Strategy Group and University of Maryland professor of public policy. And we have Dr. Andrew Polk, who's an associate professor of history at Middle Tennessee State University and the author of the critically acclaimed book, Faith and Freedom, Propaganda, Presidential Politics, and the Making of an American Religion. Guys, it's great to have you here with us and looking forward to our conversation today. You know, when I look at pieces of legislation, sometimes you look at them and they're kind of staid. But when I saw this particular piece of legislation, it also caused me to smile and say, hadn't thought about that. New York lawmakers have introduced a bill that would require restaurants that are in the state highway system rest areas to operate 7 days a week. A measure apparently aimed at really interfering with the policy of one of the fast food chains that currently exist in some of those rest stops, and that is Chick-fil-A. And Chick-fil-A has got a policy for religious reasons that they are always closed on Sunday. But the bill actually is put in place, not saying that they should be in a position where they must shut down and open up and shut down and open up what currently exists. But what they're saying is that going forward, this is something we want to make sure that takes place. Now, I don't know what it is about chicken sandwiches. For some reason, all of a sudden, America was losing its mind over chicken sandwiches. And I've got no qualms with Chick-fil-A because I've been there a few times. But the idea that we've got to create legislation based on one particular fast food restaurant, I find it to be very intriguing. But on the other hand, the idea that you're telling this group, who's made it very clear, almost even as part of their marketing strategies, that they're never open on Sundays, that now you think it's a good idea for them to have to open up, or else they're cut out from being part of the system in New York as it relates to rest stops. You know, Andre, have I lost my mind here? Or when we start having legislative groups now starting to put in place things to ensure what hours and days that I can get a chicken sandwich, I mean, do they have nothing better to do with their time? But in the same breath, should Chick-fil-A be forced to do something that they've made crystal clear is violative of what they believe from a religious standpoint? I mean, which side do we go on this, or has somebody gone too far?
Government regulation of businesses is not new. Right. I mean, it's for restaurants, it's intended to keep the public safe and free from health concerns. This legislation was intended to provide the public variety of food choices as they go through the expressway. Never mind the religious affiliation of the ownership or the management of a company. A state that is going to dictate the times and hours of operation, I mean, that's overreach, government overreach at its best or worst. Where this gets problematic is now when you add this religious component, this religious affiliation component. Sunday is widely recognized as a day of worship, and Chick-fil-A was expressly named in the legislative briefings as a targeted business in favor of this bill. So this is very, very dangerous territory. If you don't agree with a business or its management philosophy or religious position or political affiliation, this is capitalist America. Don't patronize the business. And I think people of all political partisan stripes can agree with that. But for a state to regulate a business ostensibly for their religious beliefs or political opinion, that's blatant overreach.
That's such an interesting perspective, Andre. I think this is a case that's a bit like an iceberg, that you see a little bit on top, but there's a whole lot going on beneath the surface. I mean, as you pointed out, Chick-fil-A has not made a lot of friends on the politically progressive side of the ledger. I mean, they have shown a willingness to throw their voice behind certain culture war issues. They had a long-running campaign against same-sex marriage. And there is this sort of sense that you have, that this legislation is kind of motivated by, you know, a payback, a wish to pay back, or to hurt a company that is associated with conservative Christian values. But having said that, you know, when I'm on a road trip, the quality of food at service centers matters a lot to me. And it seems to me that a state has a legitimate interest in making sure that there are, you know, decent food options at rest centers. I mean, this is a legitimate concern, especially when there's small centers. There may only be one other outlet available. So, you know, I think you're right, Andre. I think this is it's problematic, especially in its specific targeting at Chick-fil-A. But I do think that there's a legitimate policy discussion to be had about the extent of a state's interest in providing quality options at rest stops every day of the week, not just 6 days of the week.
But you know, Rushern, when I think about what's going on here, and I was fortunate, you and I actually know the Attorney General for the state of New York quite well. And when I had a chance to reach out to Tish James to say, what is this all about? Her response is that, you know, Sundays is one of the busiest days from a travel standpoint coming through the state of New York. And most of the locations only have 2 or 3 options. And if you have one option that closes down 1/3 of the facility on the busiest day that's operating, then maybe this isn't really something that's just about Chick-fil-A, and it's more about making sure those options that are there and someone like Bettina can have the type of meal that makes her feel good while she's on the road. I mean, are we missing something here, Bake, or does that sound reasonable?
No, I think your classmate is onto something, although I would add it probably helped that it is Chick-fil-A and you want to go after them. But as a legislator, and in her case, as a former legislator, she understands that these are exclusive contracts you get on the highway. And so to have a major entity that's providing food that where people are traveling to shut down is unfair. So it's not saying that Chick-fil-A can't operate the way it wants to, but it can't operate on the state highway where you have these exclusive contracts and you have you're providing services. Imagine if one of the, Shell Gas or something like that decided, I don't want to serve on Saturday or Friday. And you're on these major highways. So I think that's the part of it that I think gets to Chick-fil-A. But it didn't help that Chick-fil-A's cause that, I'm sure people were like, listen, we love the sandwiches, but we hate their politics. And so this is a way of getting it done. But certainly the state and legislatures have a right to provide services and are expected to provide those services as people are traveling.
Andrew, what do you think? Overreach or something that probably you can understand the compelling state interest?
Yeah, when I first heard about this when it happened, I had a little bit of whiplash because I assumed that the issue was Chick-fil-A was the restaurant in some of these stops, right? So if it's closed on Sunday and you're traveling on Sunday, you don't have access to food, that matters, right? And if the state is running these and they have options. As I looked further into it, the state explicitly says in all of these locations where Chick-fil-A already is, there's at least one other restaurant, often 2, plus the convenience store. And I don't really know when we got a constitutional right to chicken sandwiches. I love them. But there's a difference between they're closed, so we don't have a food option, the state needs to provide that, and not having enough variety or preferred variety in the food when you stop. Because this is a variety option thing, it's hard for me to believe this is anything other than because it's Chick-fil-A. It just becomes absurd, this tit for tat. Again, if you want to boycott Bud Light or Hobby Lobby or Chick-fil-A or Target or whatever it is now, that's fine. That's the way we work in a free economy. But when the state comes in and says, no, you have to be in this way because we need to provide options for travelers, it just seems like a step too far for me.
But Andre, it looks like the legislature is simply saying, listen, we know you're already where you exist. We're not saying that you've got to open on Sundays where you exist, but going forward, we just can't have any more of this because this is causing a negative impact. On one hand, I can understand that there's some groups that have problems with Chick-fil-A, and I also understand that there's some legislators that when they find out they can't get a franchise, that they start creating legislation to be almost retaliatory when it comes to that as well. Whether that's the case here or not, I don't know, but it just seems to me that as long as you're making sure that you're handling this on a going forward basis, I'm not sure that can be viewed as being unreasonable.
Yeah, and like I said in my comments, and my earlier comments, is I have no opposition to reasonable government regulation, but my business is my business, and so if I choose to operate on certain days and close on a Wednesday, as a business owner, that should be my prerogative, and so I believe this. In the corporate world, even when it comes to social media, if I'm going to be playing in Facebook or TikTok or Instagram's sandbox, I'm in their sandbox. They have the full prerogative to regulate my activity there. But just stay. Government just needs to stay out of this issue completely.
Well, Bettina, I see the flip side of this coming though. Chick-fil-A is now being told that you can't be in any of our other rest stops because now you have to be open on Sunday. I see Chick-fil-A at some point saying, whoa, penalty on that play. We want to be in the rest stop. We want to be closed on Sunday. And then now we're going to see where that plays out. And I'm not sure that the state really will have a strong leg to stand on, or maybe they do.
Chick-fil-A is currently in a number of franchises. They have franchises in, I believe it's something like 10 of the rest stops, and they've held them for quite some time. The existing contract states clearly that they must be open 7 days a week, and yet they were still awarded the contract. They knew going into the contract they couldn't fulfill the terms of the contract. So what was going on there? What happened? Why was the contract awarded in the first place, and why has it now become an issue? And I think that goes to the concerns that have been raised here, that there has been a precipitating issue that is clearly focused on religion, and that has been made clear from the facts around the case.
And I think that's the real concern here. You can start taking shots at a group for religious reasons and try to shroud it in probably anything else that you can come up with. Andrew, I'm kind of let you be the last word on this, because when you start talking about, especially in your book, the idea of, it's almost like America is almost creating different religions every time some piece of legislation comes out, and they're not supposed to be in that business. But when you see something like this, where you want to codify this and get a legislator to sign off on it, it almost seems like you're creating something that was never intended to be created.
There's a point where that we've gotten there, where we color these issues with availability and freedom and access, and in reality, we're often just talking about my team making a point so that I understand, right? So that my people understand that I'm on their side and we're going to do it right. It has very little to do with freedom. It has very little to do with access, has very little to do with people in large measure. It is us showing that we are on your side and we are going to take care of you and we're going to get the other guy. And that's the one that always gets us. It's not just us winning. We win when the other side loses. So increasingly, it seems all sides are just wanting the other to lose. And I have no idea why chicken sandwiches have anything to do with the real things that matter in the world and that deal with people.
Well, I got to tell you, I think a great legislator once said that any policy you create that's directed only at one entity is probably going to be bad law. And that's probably what we're going to see here as well. There's a case that I saw in the state of New Jersey, which is entitled Shlomo Hyman versus Rosenbaum Yeshiva of North Jersey. And in this particular case, we have the Rosenbaum Yeshiva of North Jersey being an Orthodox Jewish day school in the town of River Edge. And a few years ago, Rosenbaum Yeshiva announced in a letter to parents that after consulting with religious experts, it had parted ways with a male rabbi who it said violated some of the Orthodox Jewish laws by engaging in inappropriate activities with some elementary school age children. The rabbi then sued the school and forced Rosenbaum Yeshiva to fight for its right to make its religious decisions. After 2 state courts rejected Hyman's claims against Rosenbaum Yeshiva, he appealed to the New Jersey Supreme Court, and he argued that the ministerial exception, a legal doctrine that protects religious groups' ability to select and govern their ministers, should not apply. So on one hand, he's saying that, yes, I'm part of this religious group. Yes, I agree that I'm Jewish. Yes, I agree that I don't even know if there's some issues here that we can fight about, but the ministerial exception that allows you to decide who gets to be in this role shouldn't apply to me. You know, Bettina, when you see a case like this and you start seeing this battle that could be drawn between what is the ministerial exception from a religious leadership standpoint, who gets to say who's in charge and who shouldn't be in charge, and then some of the instances where you say, well, listen, this is just the pot calling the kettle black. Why should you get to make that decision on me? You know, what do you think when you hear these type of cases, and where could we be going in the future with this?
You know, it's such a fascinating case, Orlin, because I think it illustrates pretty clearly when it comes to this doctrine, this legal doctrine of the ministerial exception, which gives religious institutions a very broad latitude to hire and fire in ways that allow them to define their own religious identity. So they're able to skirt around some non-discrimination laws that other organizations have to follow. So, you know, it's a privilege that's given to religion because it acknowledges the special nature of religion. But I think this case illustrates, you know, a problem around these cases, which is sometimes what a church or a religious organization can do under the law is maybe not what they should do under the law. This particular case involves a gentleman who, you know, there were some vague allegations made against him. I read the letter that was sent to parents. It certainly makes it seem that he's engaged in some criminal sexual conduct toward minors. Well, if that is the case, then the school should have gone through the legal process of reporting that criminal behavior. It did not. It simply made the statement that this behavior crossed a religious line, thus bringing this whole question ostensibly under the umbrella of the ministerial exception and shielding it from the ability of courts to examine it. You know, I think this displays the power of the ministerial exception and also the fact that churches and religious institutions need to be careful that they don't abuse it, they don't be perceived to be using it as a shield, as a pretext in situations where it shouldn't. This case, I think you'd have to get really into the weeds on the facts to find out whether it's a legitimate use of it or not. I'm inclined to think that it wasn't.
Yeah, you know, and I completely agree with Bettina that you know, the ministerial exception is very broad and it's very generous. You know, and I've said in a previous show that you know, religious institutions, you know, you need to stay in their lane, and you know, but it's a very wide lane where you know it almost anything that it does can be covered by the doctrine of the ministerial exception. And as you know, as one panelist said, it's, you know, when you talk to an employee that has been the subject of religious discrimination, you know, you tell them to, you know, to be a good employee because, you know, you want to be a good example. Well, that same principle applies to religious organizations, right? And so, you know, you look at cases like Hosanna Tabor and Our Lady of Guadalupe, where, you know, the courts have articulated that yes, I mean this ministerial exception is very broad and it is very wide. But we also need to be aware as religious organizations that there is a responsibility that comes with that. And you know, it's also noteworthy that the majorities in these religion cases on the Supreme Court, they're never decided on narrow 5-4 decisions. I mean, they're you know, some of them are unanimous 9-0 or 8-1, 7-2. So you know, there is an established jurisprudence on the Supreme Court for the ministerial exception in the First Amendment.
You know, Andrew, one of the things that I find interesting whenever we look at these concepts is, you know, I always like looking at, one of my favorite movies was James Bond, where it talks about a secret agent that has a license to kill. But what a lot of people don't understand is in the area of religion, when you get these special exceptions, you actually have a license to discriminate. And the question is, are you using this license in an appropriate fashion, or you're using it simply as a sword to cut somebody that you have an issue with and then try to shroud it behind the idea that, in this case, a ministerial exception. And that seems to be one of the issues that we always have to be careful with. When are you simply focusing on ministerial exception, or when are you actually abusing your license to discriminate?
Yeah, I think that's the key issue that religious freedom issues have developed in recently. And it becomes even more problematic because in this case, Yeshiva is obviously a religious school, but it's a religious school. This happens in other groups, sects, denominations, traditions, everything else, right? There is a difference of, well, he's a rabbi, right? He's a religious authority figure. He's called that. He knows that. This is explicit. But he's not in a religious organization as in head of a synagogue, right? Or a minister in a church, right? This is a religious school. And so this kind of blanket, we can do what we want because of religious school, it becomes increasingly difficult, as Bettina said. This case particularly, I'm not really sure why they did it the way that they did it. What the investigation found, I would say, in any secular institution where I am in a state college, it was inappropriate. Right? This is 4th and 5th grade girls that he's massaging them, right? No explicit sexual contact was found, but it's stuff that I think anyone would say is inappropriate interaction between an adult and a child. That is pretty founded of what you do when that happens, right? There are processes which you go through with this, and it becomes problematic of, no, that's against our religious principle, and so you're gone. If you are going to be a religious institution, a school, playing in the public sphere, you have to play by the rules of the public sphere also. Mm-hmm. Oh, you're religious. No, you have your own rules and theology and doctrine. That's fine. But there has to be a tension there. I think that's the key. Whenever either side says, no, there's no tension, it's straight ahead, we get issues like this where it becomes increasingly problematic.
Yeah, Rushern, what's your thoughts on this?
I agree with the panelists. I think, the problem is, as Andre said and as Bettina said, there was a chance for this religious organization, this school, to actually go the way we think it should have went, and that is to go to the court system and report this incident. Instead, they used the religious institution. And the problem is, in our society, we give religious institution a wide latitude because we protect them, just like freedom of speech. But when stuff like this happens, what always seems to be the boomerang is that legislators start to look at how do we start reducing that wide latitude that we've given our religious organization. They start chopping at it. So they're not doing themselves or other religious organizations a favor by taking something that's so obvious that should have went to the court system and to the prosecutors and saying, using this exception. Because some legislator out there, I guarantee you, will figure out ways on how they can start chopping back and saying, we've gone too far the other way with this wide latitude we've given religious organizations. Maybe we need to clamp down and have more of the secular footprint into religious organizations.
It's interesting to me that I think the Supreme Court has kind of given a hint on how it would come down on the key issue in this particular case, which is defamation, the civil issue of defamation outside the scope of the ministerial exception. There was a very similar case that wound up through the Second Circuit, I believe it was last year, involving an Orthodox priest who claimed defamation. And the Second Circuit held that he was able to pursue that claim because there were secular neutral facts involved in the case. It was a very fact-dependent analysis, but there were secular neutral facts that the court could examine without getting tangled up in religious issues. Now, the church appealed for cert to the Supreme Court. The Supreme Court denied cert and let that ruling stand, which suggests to me that there is going to be some latitude there for defamation suits that can proceed without the courts getting involved in religious doctrine.
You know, Andre, you advise organizations from a religious perspective as it relates to legal issues. It seems to me that one of the charges has to be you're also required to be a good citizen in the community that you're in. And part of good citizenry is being able to let people know if there are people who could be, quote unquote, a danger to the community. If this individual is a danger to your school, part of the reason that we have the process we have is to make sure that it's something that more people are made aware of. How do you go about advising some of the groups that you have to deal with to understand we have our religious beliefs, but we still must be a very, what I would call, good neighbor in the midst of the community where we are?
Yeah, that's exactly right. You know, as a denominational attorney, I say, you know, even though I work for a church, we're still a business. We're still part of the community that we serve, and public image is everything. You know, and so, you know, we want to be good neighbors and good citizens, and so that I tell our pastors and our church leaders that the ministerial exception, it comes with responsibility. And so I agree with Rushern that I think that in time we will see some legislative fixes, I guess, to address kind of the secular pieces of the ministerial exception to create, I guess, exceptions to the ministerial exception. And so I wouldn't be surprised if we see legislation coming down on that in future legislative terms, either on the state or federal level.
Well, I'm going to let that be the last word, but I think you're right on point there that religious organizations have to understand that you have the protection to do what you would like to do from a religious standpoint, but you're still responsible for being a critical part of the community. And when you can be a good neighbor, your Bible calls you to be that as well, at all times. Andrew, tell me something I don't know.
Well, if you do love Chick-fil-A, and especially that Chick-fil-A sauce, and I'm not revealing any corporate secrets here, they've said it. It turns out the Chick-fil-A sauce is simply a mixture of honey mustard, barbecue, and ranch. That's all it is.
That's it. Wow. Baker, tell me something I don't know.
Did you know that Harriet Tubman, when not freeing enslaved people, she actually worked during her time off to raise the money so that she could go back and free enslaved people? So she did double duty.
Wasn't aware of that. Andre, tell me something I don't know.
There are only 3 states in the union that do not have a Chick-fil-A: Alaska, Hawaii, and Vermont.
What kind of states are those? Bettina, tell me something I don't know.
We're on a Chick-fil-A roll here. Did you know, Orlin, that the first name that they tried out for Chick-fil-A back in 1960-something was not as snappy as the current name? It was Dwarf House. and that was because it had a very short menu.
No, I did not know that one. Boy, you learn something new every day working with these panelists. This was a great conversation today. Thanks again for being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.